Great, so we've got the recording going. This is the October 20th, 2025 meeting of the Performance Standards Work Group for Habeas cases. I am going to start sharing my screen, and we will pick up a little bit where we left off last time. Everybody see that okay? All right. So Tara, just before the meeting, emailed a draft around. I did a quick scan of it. It looks like, and Tara, correct me if I'm wrong, but it looks like your major notes and comments are starting about section 7, which is after where we've already been. The one I pulled out for sections that we've already discussed is in the expert witness section. You mentioned that lawyers should be attempting to maintain the anonymity of their experts.
It's strategic. So it's just, I would put this more like, it's a strategic thing. You can choose whether to disclose them or not, but it's a particular of Oregon law. There may be reasons why you want to get a declaration with your expert's name on it in front of the judge, because it's advantageous to have that. And there may be times when it's not. So I would put it more like not a mandate, but you don't have to disclose pretrial under this case. Choose strategically whether it's it's advantageous to your case or not. And then I would clarify that for the declarations, this is about, you can draft declarations anonymously. Typically you wouldn't, but with an expert, if you want to submit a declaration, you can draft it anonymously as well to get that in front of the court.
Okay, so it's more lawyers may use anonymous declarations.
And now, the DOC is doing this a lot. They're not actually, I rarely have any information from their trial materials. I get like a 5-page trial memo and no declarations, because they love this. They love being able to keep this secret. I don't think it works with some judges though. So, some judges are going to want to sit with the materials and know who it is and don't appreciate the cloak and dagger, but it may be very useful to do it as well.
Okay. Anybody else have thoughts on that, or do we want to include it or no?
That seems fine to me.
Okay.
I wouldn't say should not disclose the identity. Because again, it's like, I would say the lawyer can choose not to disclose the identity.
I'm going to spell check that later.
And I would add whether to choose disclose the identity of experts pre-trial.
Like that?
Yeah.
Okay.
And I added a reference to this earlier in the expert section also in the draft I sent over.
Okay. reference to what now? Sorry.
I added a reference to not having to disclose attorneys or
Mhm.
not having to disclose the expert pretrial earlier in the expert section. Or maybe it wasn't the expert section. It was a section where it seemed appropriate.
Okay, maybe that's in the discovery bit. Well, I will go back and make sure that we've got all of your notes accounted for in the working draft too.
Cool.
That was just the one I pulled out. All right, so then this was the other work. Tara emailed me her demand for not discovery, disclosure. And these were the kind of big sections that I pulled out of that. For our purposes, does anybody have anything to change in that or that they'd like to see added?
I think there's a lot that can be added.
Okay.
I mean, I know the language is kind of clunky in the RFP I sent, but this would.
Yeah, and I did try to slim it down for our purposes rather than let's do this. Tara, if you don't mind, I'll just side by side the document you sent me with what we've got here. And we can all take a look.
Can you make that bigger, please?
Maybe.
Maybe. There we go.
Yes.
Well, I guess it does track with kind of the main sections, but you know, people should have like a sample that has the other language in it. So it's more complete, or they'll withhold all kinds of stuff.
Yeah, and I think our goal is not necessarily to provide people with the actual language that they should be using. It's more to provide kind of a floor for what people need to be asking for, not necessarily the way they're asking for it.
Gotcha. I might add that some other categories of records that may be relevant are like PREA records, Prison Rape Elimination Act records, or related. Those are records that come up a lot in my cases.
Just a quick clarifying question. Are we doing separate, is this set of standards just for conditions of confinement cases? I think that's how we've been writing them. And I realized.
I think ideally, no.
Yeah.
It would encompass both of them.
They're so different.
Okay.
Like the stuff that you would request, like none of this would be relevant, or I mean, maybe something in here would be relevant for like authority for confinement or like extradition cases. but they're going to be like, the substance is going to be really different, and like what you need to get, which might be, yeah.
Yeah.
There might be a way to like, after we do finish this, to like go back in and kind of create like a duplicate and kind of cut it down to, and just edit that down to what makes sense for like authority for confinement and or extradition cases.
Okay.
Just, I think, yeah, I do think we
Yeah,
should
let's
flag
think
somewhere that
about
this is
that.
really conditions of confinement specific.
Yeah.
What about is the rest of it pretty much crossover so far? Or do you
I don't
think
know.
that, yeah. What do you think, Ed?
There were a couple things I raised the question about, and we had said, yeah, it does, but so I don't know point by
Okay.
point specific.
So maybe,
like-
yeah, maybe there's more overlap than
Okay.
of what at least of what we've done so far. Maybe there's a lot of overlap.
I was just thinking maybe you could do like, if there is a lot of overlap and it doesn't need to be like a bifurcated standard, you could just say for conditions of confinement cases, these are the
Right.
documents you would want. For the other ones, you'd ask for these documents. And just
Yeah,
like
I
have
think-
sections like that.
I think ideally what we would want is we would want the kind of black letter standards to be broad enough that they apply to all the different areas of habeas cases.
I don't think that makes sense. I don't think you can do
Then-
that. Conditions of
Okay.
confinement are so,
Mhm.
they're just totally different. Like discovery. There's like pretty limited discovery you need for authority for confinement, and like
Mhm.
experts doesn't really apply at all.
Mhm.
And like extradition cases are a whole different weird thing
Yeah.
that nobody really knows how to do. Or like, I guess it seems like if we keep it high level enough to make sense for authority of confinement cases, we're gonna miss a ton of stuff for conditions of confinement.
Okay.
Maybe I'm wrong. I don't know. That's my gut though.
Mhm.
And I think when there's too much,
You don't want it to be overbroad.
I think we
because then you
used to
miss
have a
stuff and-
time when conditions of confinement cases were not litigated the way that Tara litigates them and others, like Ed, and weren't, like, the record just really wasn't developed the way it needs to be. And I'd just be
Mhm.
nervous about like setting up standards where it'd be easy to slip back into that
Mhm.
world.
Okay.
So maybe there needs to be two.
Or maybe there's just a way to like make a note to specify kind of what applies to what, like Tara was saying.
Yeah. That I think is a concern that bears thinking about for more than just the few minutes that we're going to think about it here. So
Yeah, for sure. That's fine.
Let's keep going with what
Yeah.
we've been doing here. We'll circle back around to that. We've got a little bit of time on this, not a ton. We're supposed to be on a hard deadline for the end of November. If we need to develop a whole other set of things, then we'll do what we need to do. But
I don't think we would need to do like from scratch kind of thing. I think
Right.
it would be like more paring it down or something like that.
yeah, this applies
maybe
here.
it's-
This doesn't apply here.
Yeah, and maybe it's not that. Maybe there isn't actually that much that would need to change.
Okay.
Yeah, I'm happy to look through.
Yeah,
it.
let's
Yeah.
run back through what we've got with an eye toward that.
Yeah.
Hey, Ginger.
Hi, guys. Thanks.
Hey,
Okay, so at least for the conditions of confinement, requests, what else do we want? Broad categories.
Tara, do you think that we should name the dock 400 in here anywhere?
I was wondering, if we do, you want to probably add a little, caveat it that it'll be harder to get them, but they're really important. But yeah, it makes sense to add that in as the 400 is the internal prison file for a plaintiff, and it has like everything, and they don't ever want you to have it. So it's something that is incredibly useful. So we should, a line would be appropriate. Yeah.
So what is it called? The
So the-
400 file?
DOC 400. So capital DOC, then 400 with no space.
And is there like a one sentence definition of what that is? Just their whole prison record file, or?
No,
Yeah.
well, it's an electronic file.
Yeah. And it's everything.
Like everything. I would put plain as electronic.
Okay. Anything else we want to make sure folks have?
I think that's a good summary.
Okay. And let's switch back to just our.
Can I just add one thing for that PRIA one?
Sure.
I don't know if we want to specify that this includes the SIU file or the any SIU investigation documents.
SIU.
Special Investigation Unit.
Like that.
Mm-hmm. We have requests. That was the only addition that I was thinking of.
Great. Okay, so then let's drop back down to where we left off last time. Filing and arguing motions. What kind of motions practice do y'all have in habeas cases? Are there a ton of pretrial motions, or?
No. They're doing more motions to dismiss than they have, but there's actually a requirement in the statutes that there shouldn't be pretrial motions, and the one pretrial motion exception is summary judgment or motion to dismiss. But motions in limine, of course, can still be filed, or motions for extensions or continuing trial, stuff like that. But like the big beefy motions are really not to be. They slow the process down. It's actually it bars motions practice, the statute. Yeah.
Do you remember with the COVID cases, they were moving to quash all those subpoenas? Are they still doing that?
No, I haven't had that happen since then. So like the little,
Only things I litigated were motions to compel and, you know, and just like evidentiary motions.
yeah, there's a lot of motions to compel.
Did we, I can't remember, did we talk about that in the discovery piece?
I feel like
I think we
talked
did.
about this.
I think
Yeah.
we might have.
So for the title of the standard,
Yeah.
I feel like maybe it should be filing and responding,
Okay. And make sure
or
we cover
filing,
the motion to
arguing, and
compel.
responding.
Yeah. Okay. Where are we going? There we go. We could do that. Yeah, that makes sense.
And I don't, Tara, tell me if you think this is correct. I don't think that there's anything barring us from, I mean, other than they're difficult to win, but for us filing a motion for summary judgment,
Oh yeah, we could file one. For
if
sure.
people were so inclined.
Yeah.
Is this, I'm a little, don't we have isn't the standard right before this pre-hearing motions?
Oh, I don't know.
Didn't we just do
Oh, it
this?
is.
Okay,
So I don't
Why
know,
is
if-
this
is this
duplicated?
different?
hopefully our answers were the same.
No, they were.
I think so. I remember this conversation.
Yeah.
Yeah, we did have this.
Yeah, let's pull this one. I don't
Oh my gosh,
think
thank you, Meg.
it adds to that. Thanks, Meg. That was gonna.
That was good.
Why are you doubling
Yeah.
up?
Reasons, I'm sure. I'm sure they're good reasons, but not good enough to keep. All right. This one I pulled over from some of the other standards that we're working on, because I don't know how working with diminished capacity clients works in habeas cases, but I assume it happens with enough frequency that we want to have something in there about it. I assume you don't have a right to be fit for your habeas case, but I don't know that.
It's different. Many clients are deteriorated because of mental health. Many,
Mhm.
and that's a key feature. It's not the same standard as in criminal law. It doesn't even. I mean, if you have a client who's really, really, really incapacitated, you could possibly get a guardian, ask the court to, but that doesn't, that's like worst case scenario. And I've never had a case where we needed to do it.
So we just talked about this in the post-conviction. So, and I don't know how it applies. So generally when you're talking about a guardian ad litem, if your client hasn't requested it, it's adverse proceeding against your client. So you can't request the guardian unless your client has requested you do so.
Mm.
I think the habeas is interesting because if the habeas is filed based on, improper treatment of a mental health condition and your client has filed it, then I feel like they're consenting not to the guardian ad litem, but consenting for you to move forward with that case.
Mm-hmm.
I don't know, I haven't found any really clear direction with regard to what to do. Like, for example, when your client is so diminished that they won't show up for phone calls and stuff in proceedings.
Hmm.
I don't know if it's, well, it doesn't sound like Tara's really had, that's not something that comes up in habeas a lot, and it didn't come up when I was doing a lot of habeas either.
It's just so like they want you to help them.
Yeah.
And that's really the only question is, will you help us? And that doesn't take a whole lot to be able to express. And so it's not really an issue. I've had it come up once with one client, just in the sense that it was just as far as that issue ever went. But generally it just doesn't arise. I mean, as long as you know how to talk
Okay.
to somebody and like, who's compromised and be patient, then it's really more kind of like learn how to do that on the attorney side.
So maybe something broader, lawyers should be able to recognize the symptoms of clients with um,
I mean, I definitely have clients who are floridly mentally ill, but
Mhm.
it's just, usually I have a psychiatrist on the case. And if there's an issue where I feel like we can't communicate, I may call in the psychiatrist to help us out.
I think I would be the most comfortable with running this rule by a ethics attorney. I mean,
Mhm.
this is
So we
not an
did.
area I feel comfortable talking about or making decisions about.
Sure. That makes sense. So we did run. I put it. We did run something similar by Bar Ethics Council. Is when an attorney question is when an attorney is representing a client in either the post-conviction or habeas realm, the client has diminished capacity. Can the attorney ethically ask for / advocate for a guardian ad litem for their client? Related to that question, is it ethical to proceed without a GAL in those circumstances? The bar's response was lengthy, but their short answer, and I'll send you all the
I
full
would
text
love
of
to
it.
see that.
Their short answer is yes, there are scenarios where it is appropriate for attorneys to seek the appointment of GAL when their client has diminished capacity. Then they go on to elaborate quite a bit. So let's do this. Let's come back to this one. And I will email this answer around all of you, and we can see what everyone thinks. Tara, are you trying to join again?
I am, because I lost my box. I can't find it.
Okay.
I don't know where it went.
See if that works.
Thank you. Oh, now I'm double
Now you're
up.
in stereo.
Oh dear.
I'm going to mute one of you.
Definitely do that.
Okay.
Thank you.
So let's come back to this one. You OSB 16 now. All right. Obligation to renew motions during trial. I suppose if your motion in limine, if you're using motions in limine, this still applies. This should really be right after the motion section. I suppose you all tell me if you think that still applies. Yay or nay?
I can't think of a scenario where this would come up, but that doesn't mean it shouldn't be in there.
I might see that coming up in, are you getting a double?
No.
Are you, okay. I may see that coming up in the context of like excluding witnesses, and then you get more information during trial. And by excluding, I mean the court not allowing witnesses, which has happened. So it seems valuable to have in there.
Any commentary or clarification you want to add on this, or is it just it stands alone and it is what it is?
I think it's pretty clear.
Well, yeah, and I guess if you get a lot of discovery that supports your motion for summary judgment, then you would want to renew it.
Okay. So moving on to the next one. Do habeas cases ever settle?
Not mine.
Yeah, they do.
Like, I assumed it was theoretically possible, but I've never heard of it,
I've heard of it.
which is not yeah.
Yeah, some of them do.
Okay.
But
Yeah,
I don't know.
I had cases that were stayed. They were stayed while the prison medical was supposed to be doing things, and then ultimately dismissed.
Yeah,
We had
That's-
those. We had a
yeah.
unique settlement situation around COVID cases, but
Right.
Tara's
Hmm.
familiar with that.
Yeah, I've heard the same like procedure that Ed just mentioned of like kind of informally settling and just like staying the case until certain treatment has been provided and then dismissing.
They do settle a lot of the time, just not in my cases.
Just
Call
yeah, but I
trial
don't know
all the
anything
time.
about those procedures.
Or hold them in abeyance. That's kind of, the easiest way that people do these settlement type things.
You all comfortable requiring people to explore dispositions without trial?
Yeah, I think in particular, I know Tara, we were talking way back about the effect of res judicata habeas to like a damages claim, and it seems like in your favor that's gone further and further to be the case, right?
Mm-hmm. Yeah. all my habeas cases that have won, now they're all 1983s.
And so if you can have a jury trial on damages and you're risking a bench trial with, a Malheur County, Umatilla County judge, you got to really consider if you think you have a
Yeah.
damages claim, if you're going to risk losing on those issues in a habeas case.
And I think they might be turning. I wouldn't enter settlements anymore since COVID because DOC was so untrustworthy and they walked away from the terms of almost every settlement. People had to bring them back years later, but it may be changing. So settlement is always, especially if you have a immediate issue for your client and they don't want to wait a year for trial. It's definitely something to explore.
Okay. So Ed, with what you were saying about the 1983 cases, does that kind of cover what you're talking about? Lawyers should assist clients in weighing whether there are strategic advantages to be gained by settlement or continuing to trial, including the impact of settlements on future claims for damages.
Yeah, I think so. And as Tara
Okay.
said, significantly for a lot of these clients, it's how quickly are they going to get any response.
Mm-hmm. Let's add that up in here. So adding the timeframes for addressing clients' claims through settlement and through trial. Okay. With the consent of the client, the lawyer should explore with the defense available options to resolve the case without trial. Throughout negotiation, the lawyer must zealously advocate for the expressed interests of the client, including advocating for some benefit for the client in exchange for settlement. Keep the client fully informed.
So
Observe the
for
client's. Oh,
For
go ahead,
number
Ginger.
4, there's a extra E in judgment. The last judgment. There you go.
So there is. Thanks.
Mhm.
I think I've said it before, but just in case I haven't, spelling is not my favorite subject.
I figured it would have gotten picked up somewhere anyways, but
Better that it
since I
gets
saw
picked
it.
up here
Since
than
I
risk
saw
later.
it. Yeah.
Always please thank you and point those out, please. Thank you. Continue to take steps necessary to preserve client's rights and advance the client's case, even while engaging in settlement negotiations. And things to be familiar with before you start in negotiations. Why does that B look so? Identifying goals of the negotiation. Lawyer has a duty to inform the client the full content of any tentative negotiated settlement and to explain what those mean, the advantages and disadvantages. Lawyer should not recommend that the client enter settlement unless an appropriate investigation and evaluation of the case has taken place. Anything else on that one?
It might say this somewhere else, but if it doesn't, I would put in that an attorney has a duty to monitor whether the settlement is successful. DOC follow through with what they say they're going to. And that can
Yeah,
take
I
time.
think we have that. Um,
Oh, good. Okay,
yeah, ongoing compliance monitoring.
great.
So we do have that.
Great.
Okay. The decision to enter settlement agreement rests with the client. Lawyer must not unduly influence the decision to enter settlement. Must ensure that when a client enters a settlement, it is done voluntarily. Counsel must ensure the client has an intelligent understanding of the terms, conditions, and consequences of the settlement, including what rights the client will forfeit. Any issues with the black letter part of that?
It's good.
Okay. I left this one in. Lawyer has a duty to be familiar with local detention practices as well as statewide detention practices such as time served calculation, work release, alternatives to incarceration. That seemed relevant to me when you're talking about dealing with settling cases, and I guess just in general.
I mean, that'd be relevant for like an authority for confinement
Mhm.
case, potentially. Although, yeah,
I think it's relevant to
maybe it's
knowing what you can get for your client and how
Mhm.
long it may take and whether they're going to be around to receive the benefit and how hard to push for whatever it is. Because typically, if a person leaves prison, the habeas moots.
Okay. Well, we'll leave that.
I've had two cases recently, I think I've mentioned this, where judges extended their orders to post release. So there's some room for that. I don't know if you'd want to add that or not, but
So the judge ordered DOC to do something for the client post their release from DOC custody?
yeah, in a couple
Huh.
cases where the clients were released shortly after the orders.
Yeah. I think that would just fall under the continuing obligations post disposition.
Well, most people aren't going to know that because it's kind of newly developing. But I don't know if you want to get into that detail on kind of changing law in this.
No, probably not to any great detail. But I think to the detail we would want to get into that, I think putting it into the post disposition section would make sense.
Yeah. Just to know that
Um,
there's groundwork for that argument being successful.
Yeah. Let's finish this and then I'll drop down there and put in a note.
Well,
Lawyer has a duty to explain to the client the process the client will go through to enter a settlement. Oops. Do that. Whether there will be a hearing, nature of the hearing, And the role the client will play in the hearing. The lawyer should explain to the client that the court may, in some cases, reject settlement. I assume most of this is like, unlike plea deals, most of this is done on paper and just signed.
Mhm.
Are there ever hearings where a judge would deal with settlement?
They have to sign off. So
Mhm.
usually it's just you file it. If you have a stipulated settlement, they sign off.
Okay.
I mean, is there anything barring a judicial settlement conference? I mean, we never do them, but
Right?
Yeah.
it might be it might be a good thing to try. I've never even thought of it before. Although was it COVID litigation, it kind of reminded me of some sort of hybrid when Judge Swade got involved, but
Right.
So I think I'll pull the part about the hearing for settlement and just leave it at lawyer has an obligation to explain to the client the process the client will go through to enter a settlement and the role the court will play in that hearing during that settlement,
That makes sense.
the
or
role the
just
client will
in the,
play.
yeah, period.
Yeah. And then if during a settlement hearing, client does not understand questions being asked by the court, we can take that part out. All right. Then let's drop back down to make note to self. Add post. That'll flag us to come back to that when we get down here. Okay, it is 1:55 and we are right about where I was going to go back through and add Tara's comments. So I think this is probably a good stopping point for us. Anybody else have anything that they'd like to cover real quick? Otherwise, we'll break here and I will see you all next time.
Good to go. Thanks so much.
Thank you.
Thank you all. Thank you all for
Bye,
the work you're doing.
everybody.
Good luck.